Today we will be talking about how a company is struck off the registrar of companies. A company goes for strike off when the management no longer wishes to carry on the business further. Strike off simply means removing of the name of the company from the registrar of companies. It is dealt with in the section 248 of the Companies Act 2013 in India. It is done by two ways, by ROC, which is done compulsorily, which is done suo moto, or by company voluntarily. By ROC, when it is done by ROC, ROC can direct for a strike of a company if it has a reasonable cause to believe that a company has failed to commence its business within 1 year of its incorporation, or a company is not carrying on any business or operation for a period of two immediately preceding financial years and has not made any application within such period for obtaining the status of a dormant company, or the subscribers to the memorandum have not paid the subscription which they had undertaken to pay at the time of incorporation of a company, and Form INC 20A is not filed within 180 days. The company is not carrying on any business or operation as revealed after the physical verification after registered office of a company is found by Registrar of Companies. These are the base points on which the ROC sees if it will strike off a company by itself. A company can do it so voluntarily if uh, if it makes an application to the ROC to strike off its company, extinguishing all its liabilities. However, the shareholders' approval is required by special resolution before making such a decision. The procedure for the same would be step 1. A board meeting would be held where board of directors will approve of the following transactions. It will approve of the strike-off of the company. Authorization will be given to any director to apply the same to ROC, and issuance of a notice for extraordinary general meeting. After that, step 2 will take place, in which, after passing of the board resolution, all liabilities existing in the company uh, will uh, will be dealt with and will be extinguished. Step 3: an extraordinary general meeting will be held uh, to pass the special resolution for strike-off of the company, in which at least a special resolution is when three-fourth of three-fourth of the attending members approve of the resolution. The concerned authority will then issue its approval. Um, this will only take place when any other regulatory authority uh, it regulates such. If any other authority regulates the company, then the permission from that shall also be required. Step 5: an application to ROC will be filed in the form of e-form MGT 14 within 30 days of passing the resolution with a normal fee, and an e-form STK 2 with ROC shall be filed, uh, costing rupees 10,000. Attachments: the following attachments are required for STK Form STK 2: a copy of statement of account duly certified by Chartered Accountant in Form STK 8, not earlier than 30 days from the date of making application; copy of board resolution; copy of special resolution; indemnity bond in STK 3 duly notarized, collectively given by directors; affidavit in STK 4 duly notarized individually; an ID proof of directors; and a bank account closure statement. Uh, For step 6, uh, it would be seen that if it has filed its last applicable ITR, and ROC shall publicize the notice for strike off of the company. ROC will publicize it in the form STK 6, inviting any objections from the company for the proposed strike off. The objection, if any, are sent to the respective ROC within 30 days of publication of notice. After approval by ROC for strike off is received, It will issue a notification in the official gazette in Form STK 7 about the company's strike-off and dissolution. The following companies are not eligible to claim strike-off: change its name or shift its a company which has changed its name or shifted its registered office anytime during the previous 3 months, has made a disposal for value of property or rights held by it immediately before seizure of trade or otherwise carrying on of business for the purpose of disposal for gain in the normal course of trading or otherwise carrying on of business, has engaged in activities except the one which is necessary or expedient for the purpose of making an application under that section or deciding whether to do so or concluding the affairs of the company or complying with any statutory requirement. Point 4. Has made any application to the tribunal for sanctioning of a compromise or arrangement and the matter has not been finally concluded. Or number 5. Is being wound up under chapter X20 whether voluntarily or by the tribunal or under the IBC 200 2016. This is the following is the list of companies which cannot be forcefully removed by the ROC. Number 1 being listed companies. Point 2 being companies that have been delisted due to non-compliance of listing regulations or listing agreement or any other statutory laws. Point 3 being vanishing companies. 4 being companies where inspection or investigation is ordered and being carried out or action on such order are yet to be taken or were completed, but prosecution arising out of such inspection or investigation are pending in the court. Point 5. Companies where notices under Section 234 of the Companies Act 1956 or Section 206 or 207 of the Act of Companies Act 2013 have been issued by the registrar or inspector and reply thereto is pending or report under Section 208 has not yet been submitted or follow-up of instructions on report under Section 208 is pending or whether any prosecution arising out of such inquiry or scrutiny, if any, is pending with the court. Section 206 being Section 206 being the empowerment of the ROC to call for any explanation of any document submitted by the company in any of its forms. Point 7. Companies against which any prosecution for an offence is pending in any court. Point 8 being companies whose application for compounding is pending before the competent authority for compounding the offences committed by the company or any of its officers in default. Point 9. Companies which have accepted public deposits which are either outstanding or the company is in default in repayment of the same. Point 10 being companies having charges which are pending for satisfaction. And the last, companies registered under Section 25 of the Companies Act 1956 or Section 8 of the Companies Act 2013 being not-for-profit organizations, not-for-profit companies. The end.